Hey everybody, welcome to our monthly virtual programming here at Cannabis Lab. It is the third Thursday of the month where we bring you everything that you need to know about the industry. We have one of our amazing panels for you today, anchored by one of our longtime supporters, the head of the cannabis practice at Akerman, John Robbins. But before I turn it over to him, tonight, if you guys are in any of our areas, which is in Tampa, Orlando, Fort Lauderdale, or Miami, please join us at American Social. If you want to check out any of the other great events that Cannabis Lab is doing, find us on Eventbrite. Just Google Cannabis Lab Eventbrite or go to joinclab.com. If you want to check out our podcast, you can find that on LinkedIn at the Cannabis Lab or on YouTube at youtube.com/ at the Cannabis Lab. And of course, you can always go to joinclab.com for all of the information that you need to be a part of it. If you're looking to get involved with Cannabis Lab in your local city across the country, please shoot us an email and we'd be happy to tell you how you can get involved. With that being said, I will turn it over to our moderator for today's panel, John Robbins. John, take it away.
Thank you, Todd. I appreciate it. And hi, everybody. I hope everybody is having a great day. I am very excited about this panel and this topic. We are going to be talking about the state of Florida cannabis industry yesterday, today, and hopefully tomorrow. Let me begin by thanking our sponsors, C-Lab, of course, the International Cannabis Bar Association, Dutchie, and Akerman for today. And again, I'm very, very excited about the particular panel we have. These are folks that I have known and been working with for years, sometimes working together, sometimes working as adversaries. But the reality is that I can't think of a better group to talk about cannabis law in the state of Florida. I think we have a lot of mutual respect for one another. And certainly this panel is definitely at the top of their field, particularly in the state of Florida, but beyond the state of Florida as well. So I'd like to begin by introducing our panel, and I'd like to ask each of you to perhaps, rather than me just spewing out your bios, I think it'd be better if you guys spend a minute or two talking about what you do, your background, and I guess we'll begin with Courtney Coppola, who's a partner at Ballard Partners. And Courtney, just a little bit of background, prior to joining Ballard, Courtney served as the Deputy Chief of Staff for Governor Ron DeSantis, and prior to that, she served as the Director of Florida's Medical Marijuana Program, the head of the Office of Medical Marijuana Use in Florida. So tell us a little bit about what you're doing now.
Thank you so much. I've been at Ballard I'm Courtney. I've been at Ballard for just about a year and a half. When I joined the firm, we launched our National Cannabis Practice Group to align our federal, state, and local cannabis work kind of all under one umbrella. It's been extremely fulfilling to, like John mentioned, work on cannabis from this side. I was in state government for about 10 years and was fortunate enough to join the then Office of Compassionate Use as employee number 2 and work my way to finally being the director of the program, and working on this side, engaging with licensees and prospective applicants on how to interact with Florida's cannabis program, nationally, state level, and at the local level, and excited to be here with you guys today.
Great, and we're very happy to have you here with us today. Next up is Jason Fowler, who's the VP of Sales at LeafLogix Technologies, which is the Dutchie POS. Also a former rock star, by the way. Jason, tell us a little bit about, well, let's talk a little bit about Dutchie, what you do specifically, and again, a little bit about what Dutchie does specifically. Everybody on the panel, of course, knows, but perhaps not everybody who's joined the seminar knows.
Absolutely. Thanks, John. My name is Jason Fowler. I help lead up the enterprise sales side of the house for Dutchie. Dutchie has evolved, acquiring LeafLogix in March of 2021 to form the largest and best capitalized cannabis compliance software company in the world. We support over 6,000 dispensaries across the US and Canada. I'm truly excited to learn from everyone on the panel today. I've been in the cannabis space for 8 years now, which is crazy to me because every day is different. I know it's a cliche, but what I do on my day-to-day is listen to the top major operators throughout the country, those that are applying for licenses, specifically in Florida, and to understand what they're trying to solve for, and then to build a better software solution support program to support them eventually gaining access to safe and efficient cannabis with their patients and customers.
That's fantastic. And, 8 years maybe doesn't sound like a long time, but I will tell you that in this industry, it's an absolute lifetime. And I've known all you guys for probably somewhere close to 8 years, if not more. So I would certainly suggest that everybody on this team are really pioneers in the industry. And next up is Sally Peebles, who is a partner at the Vicente LLP, which is one of the pioneering firms in the space. And Sally runs their Jacksonville office. Tell us a little bit about what your firm does and what you do on a day-to-day basis.
Thank you, John. My name is Sally. I'm with the law firm of Vicente, formerly Vicente Sederberg. We are a national cannabis and psychedelics law firm. I started out in Colorado and worked there for 4 years and started in 2014. My husband was a true pioneer in the industry and jumped on board. When I would hear conversations about what they were doing, I got intrigued and jumped out of the traditional law firm to join Vicente. I moved back home to Florida, where I was born and raised. In 2018, I've been heading up our Southeast efforts. I keep tabs on what's going on all over the Southeast for the firm, and I'm barred in Oregon, Florida, and Colorado. I do a lot of corporate licensing, regulatory work, and I'm also part of our merit application team that's draft and acts as project managers for our competitive licenses like we saw in Florida recently.
Fantastic. And last, certainly not least, is Vijay Choksi, who is a counsel for Fox Rothschild law firm. Prior to that, Vijay was in-house counsel for one of Florida's first MMTCs. In fact, I think that was one of the DOs, which was the original designation from back in 2015 when it was Florida had what they called then Charlotte's Web law, which was a high CBD, low THC law. Vijay, tell us a little bit about yourself and Fox Rothschild's cannabis practice group.
Appreciate that, John. Yeah, my name is Vijay, service counsel for Fox Rothschild. Fox is a USAM 100 law firm, about 1,000 attorneys, 29 offices. I joined Fox about 2 years ago, and I was actually almost going to join you, John. Yeah, so I work primarily, actually 100% with cannabis companies. That's my client base. Similar to what Sally does, corporate regulatory compliance, helping cannabis companies understand the rules and how to operate efficiently under those rules. And that's essentially my practice.
And Vijay, too modest to tell you that he was voted best hair in the cannabis industry 7 years in a row. And he cuts it himself, by the way. Obviously, a very, very experienced panel. Presumably, everybody who has attended today's conference is aware of the fact that only a few weeks ago, about 3 weeks ago or so, Florida's most recent and only second application process sort of kicked off with the deadline for applications to be submitted for 22 additional licenses, presumably 22 additional licenses. The state, by way of background, has perhaps the biggest, if not one of the biggest, medical cannabis programs in the country. Adult use is possibly on the horizon. We're going to talk about that. And we have come a long way since 2014 when the original Charlotte's Web legislation passed, which, like I said, was a high CBD, low THC piece of legislation, provided for only 5 dispensing organizations, which is what they called them at the time. We were then mired with lots of litigation, a constitutional amendment, which ultimately expanded the program to full-blown medical cannabis use, and enacting legislation. And like I said, we are up to over 800,000 patients now in the state. There is a possibility of adult use coming in 2024, which we'll talk about. But I would like to spend just a couple of minutes, and I know that most of the people here probably want to talk about sort of what's next and what's happening now and how the application process is going to work. But let's kick it off with a little bit of background as to sort of how we got here, and sort of how the program has changed, and perhaps a little bit of an explanation of how the program works and vertical integration. And I guess who better to kick it off than Courtney. And by the way, anybody jump in at any time you want. I'm not playing favorites here. I'm just randomly picking everybody because I don't think there's anybody on this team who can answer any question I might throw their way.
No, I appreciate it very much. And I'll keep my state history brief because the exciting part is certainly what is to come in Florida's cannabis program. But like you mentioned, we started way back in 2014 with a low THC only program and 5 mandatory fully vertically integrated licenses. The state in 2015 did an application round, 28 applicants for scale, which is interesting to see how far we've come. There were 28 applicants back then. The barrier to entry was a little different. You had to be a 30-year plant nursery at 400,000 plant count from the Department of Agriculture. So not a very vast group even eligible to apply, but nonetheless, the state received 28 applications, 5 licensees, then dispensing organizations were chosen. Importantly, in 2016, a constitutional amendment passed that drastically changed Florida's cannabis landscape and our medical program, moving it from a low THC only with very, very limited conditions to a much more expansive full potency market, as the state would describe it, and a much larger, broader condition list. The legislature came in 2017, June of 2017, during a special session and kind of reworked the framework for Florida. And John, I think you'll probably have a different perspective. I was at the state at the time. The legislature passed what our structure would look like, maintaining the vertical integration and tiering licenses to become available as tied to Florida's patient population, which is how we got to the Pigford license that was the round before the general round that just closed on April 28th. So we saw a lot of transformation from a low THC only, no whole flower, no smoking program to the second largest, fastest growing medical market in the country. We have 22 vertically integrated operators today here in Florida. All of those are actually applicants from the 2015 dispensing organization round. Many of them have completed changes or transfers of ownership via the variance process. But the state just recently began engaging in competitive applications for medical marijuana treatment center licenses, first with Pigford, which one was available, and the most recent round, 22 vertically integrated licenses being available. What makes Florida so competitive and so valuable? One license is a license for unlimited everything, unlimited number of cultivation facilities and like locations and square feet. Same with processing. You can have a kitchen separate from your processing facility, unlimited fulfillment and storage facilities, which I think is a little underrated asset for delivery for our statewide operators, and of course, unlimited dispensing facilities as well. We are north of 800,000 qualified active patients, medical only. So tremendous opportunity here in Florida, with the most recent application round closing at 74 applicants for 22 available licenses. So very quick history on where we've been and the great things to come for Florida.
Fantastic. And I think we're all pretty excited. And yes, it's anticipated that 22 licenses will be given out. And you mentioned Pigford. Tell us a little bit, or maybe I'll throw it over to Vijay. Tell us a little bit about what a Pigford applicant is, how it came about. And there was a recent application process for Pigford applicants, which ultimately resulted in the promulgation of HB 387, which my understanding has not yet been signed into law by Governor DeSantis. But and I guess I'll throw it out to anybody. Let's talk about Pigford and how, if at all, we anticipate that might affect the new round of pending applications.
I'll take that one.
You don't even need to raise your hand.
Me. Well, the state held an application for just only one single license that would be awarded to a recognized class member of 2 related racial discrimination cases back against the USDA going back to the 80s and the 90s. I like to say this is Florida's version of a social equity license that a lot of states are struggling to put forth. I believe 12 applicants submitted back in March of 2022, and a winner was chosen about 6 months later. Get that question a lot. How long is it going to take to pick a winner? And then, as we see often in states that choose to limit licenses, the unsuccessful applicants then challenge that award via litigation. the important nugget here is that a couple of weeks ago, the Florida legislature did pass a bill that will hopefully settle those cases. It has yet to be signed by the governor, I don't believe, unless something happened today I didn't see. And it will award a license to those Pickford applicants that were not disqualified. So the bill is very careful to note that these licenses will reduce the total number of licenses that will be issued in the future application rounds, and it will not reduce the total number of licenses that will be issued pursuant to this most recent application round, where 74 applicants submitted for the 22 slots that ended, end of April. So I get that question a lot right now. Is it going to reduce that 22? It doesn't look like it will. But the other question is, how many will it absorb in these future rounds? I was told 6, now I'm being told 2. Some others on the call may have better insight there. But I think the key is that it will be absorbed future rounds and not this one.
Right, so for example, the current round, and this is based upon patient population. So the idea based upon the enabling statute, which is 380. 1986 Florida statutes, was that with every 100,000 patients, we're going to have 4 new licenses roll out. And when we hit 800,000 patients, we actually should have had, and correct me if I'm wrong, Courtney, 26 available licenses, but 22 are going to be given out in the next batching cycle, meaning that if they give out 4 or more Pickford licenses by default because of the new House bill, it'll come out of those 4 on top of the 22, in other words, numbers 23 through 26, and then the next 4 after that. Is that your understanding of how it'll work?
Correct. It has not been sent to the governor. The legislature has not sent it to the governor for consideration yet. But as contemplated, it preserves the general application round of 22 and directs the department, if any, to issue out of the 4 that became available when we get 800,000. And like you mentioned, every time the state hits 100,000 more, qualified active patients, 4 more would be coming available. So whatever that number is would have to come out of the future batch.
And I've also heard a wide range of anywhere between 2 and 10 Pickford applicants who will ultimately receive licenses. And that's based upon whether or not they actually qualified. There were significant sort of barriers to entry for Pickford applicants in terms of who qualifies and who does not. So the theory being that those qualified applicants will end up with a license, which I think is a good move on the part of the state, and I think it's equitable, candidly. Not that I'm here to editorialize. And again, we have, I think everybody on this call has worked with applicants in the most recent batching cycle in one capacity or another. We're going to talk about that. And these people were waiting on the sidelines since 2017 to apply and spent lots of time and money. So I'm very happy that the legislature made it clear that the additional Pickford licenses that are going to be awarded aren't going to be coming out of the 22 that should be awarded this round. Obviously, we just got done, like we said, with the most recent application process or cycle. All of these applications were due at the end of April. There were 74 applicants, and like I said, everybody on the panel here has gotten to work with at least one, if not several, applicants. Vijay, tell us a little bit about the process, because it was both extensive and expensive, and I can tell you from personal experience that even getting down to the wire, it was a mad a scramble, even for people who have been working on this for 5 years, because the application did change a bit over time. And so tell us about your experience and your client's experience with that process, and sort of what you think were sort of important factors. For those of you who don't know, there were several categories to the application. They are weighted and graded, and certain number of points are given to each category. It's an extremely complicated process, but one of the reasons that people need good professionals, either on the technology side, like Jason, or legal or accounting or lobbying or policy work, is because it's so hard to work through and figure out strategically what makes the most sense. Vijay, tell us a little bit about that.
Yeah, for sure. So essentially, let me start with, I guess, the black farmers, because as you mentioned, I think we all have clients in that space and we're still trying to work through that. There was 12 applicants for that black farmer license. I believe individual Terry Gwynn received that notice of intent to award. So 11 received the notice of intent to deny. And essentially, if we have one of those 11 clients, or you're working with one of those 11 individuals, the course is now a bit uncertain. Of course, there's litigation ensuing, but what happens next? You already put forth your application. There's a wide variety of options you can possibly pursue, including petition for administrative hearing. That doesn't work, provide some type of civil route. And if that doesn't work, you may just want to do a TRO. However, the latter option is probably a bit extreme and may put a bomb on this whole process of getting anyone licensed for the black farmers. As it results to the new batch of applications, it was substantially similar, in my opinion, to what was put forth by OMU during the black farmer application round. A little bits have changed here and there, but in essence, it's still a merit-based application. So rather than check the boxes, there are weighted boxes that get awarded points from all aspects of the operation. Florida being vertically integrated, it's about 8 businesses in one. You're a farmer, processor, kitchen, retailer, marketer, so forth and so on. So in essence, what we do, or at least my experience, is more of a quarterback overseeing the application, it coming together, as well as drafting agreements from real estate perspective, as well as MSAs, corporate documents, how those all tie together. But for at least my experience, I try to shy clients away from the actual law firm writing the application soup to nuts. The economic expense of paying a billable hour to put forth this mega application is just, in my opinion, economically not smart in the client's perspective. But at the same time, you need a team of people because, like you said, John, there's people waiting in the wings for about 5 years trying to put forth these applications. So if you got a call, or I got a call, say 3 months before the deadline was due, which I did, in fact, actually 3 weeks before the deadline was due, saying, hey, can we put forth an application? I mean, we could try, but, again, people were waiting in the wings 5 years to put forth an application.
Which raises an interesting issue. And I said, Vijay or Sally, maybe you may have a situation where these applications would require you to disclose cultivation locations, dispensing locations. People were procuring leases or sometimes contingent leases that sort of kept in a holding pattern until they find out whether or not they actually received an award. Some people have been working on this for years and years and years, and ultimately some of this information goes stale. You lose that contingent lease. You lose your medical director because another opportunity comes along. How did you guys sort of struggle and deal with those issues? Sally?
I think part of it is just making sure you have solid, certain information coming from a good GR team as to timing, and you want to get that early on and go into these leases with eyes open, especially with this litigation. It was very clear for us to be able to guide clients and say, you're going to want a due diligence, a year due diligence if you can get it. Now, who's given you a year due diligence? Very few free looks are going to be for a year, but you try to get that as much as possible. You tell clients to understand that they're going to have to maybe put some sort of structured deposit down. You lose 10 grand every 3 months or something like that, but you try to be creative and you make sure that the clients understand and these applicants know that they're going to lose some money to try to hold on to these properties. And then you need to balance with, okay, if there's capital issues, maybe it's better to let some go and then be able to come up with some sort of as good of, if not better than, property later, and hope that doesn't open you up to challenges if you do indeed get a license and you have the unsuccessful applicants coming after you. So it's a balancing game, but I think making sure you have a clear team advising you on best strategies is the best way forward.
Yeah, and I agree with that. And point well taken in terms of not only will you may have to deal with other applicants in litigation after the process is done, but let's assume you're lucky enough to be awarded a license or you get a notice of intent to award a license. You're going to have to satisfy the state and the Department of Health, OMMU, that ultimately in practice, and you have a limited amount of time to get cultivation authority and then processing authority and then dispensing authority. And not only do you have to comply with the regulatory requirements, but you also have to satisfy the OMMU that everything you are doing is going to coincide or be consistent with what you put down in the application. And so even if you have something as what you might think is benign, like you have switched seed sale tracking software, and I want to talk about that with you in a second, Jason, or perhaps a new cultivation facility, you actually have to submit a variance and get that approved. And if the DOH does not think that it meets the level as reflected in your application, you're going to have a problem, and it may not be approved. And this is a very expensive undertaking. Like Courtney said, a lot of these licenses were bought effectively on the secondary market, and a lot of these companies paid a great deal of money for these licenses, and they should get what they paid for. And Jason, you come at this from a little bit of a different perspective, because we've been discussing the requirements and barriers to entry in these applications, and part of that required not only all the stuff we've been talking about, but also a seed to sale tracking software platform, which I want you to tell us what exactly that is. You have to have SOPs for just about everything you do. You have to have security protocols. You have to have a POS system. You have to make sure that whatever systems you are getting are able to communicate with the state system, with the registry, and with all of your other systems. So tell me how Dutchie has been able to help potential applicants in putting together their applications. And then of course we'll talk about later, okay, now you got your license and now you guys are really running the show, what how you can help these MMTCs as opposed to applicants.
I'll try to unpack that, John. I appreciate
I'll have to unpack, sorry.
I'm the token geek squad on this call. You'll have to forgive me. Obviously, I work for Dutchie. This is not a Dutchie advertisement. This is what you should know. Perhaps you don't know, but you already do. Worth rehashing. So from a software compliance perspective, regardless of what vendor you're working with, there are core questions you should be asking yourself. And I commiserate with all the applicants. We've helped a lot of applicants with their inventory tracking management, what they need for that application. We call it the Powerball. If you do win, so happy for you. Florida is such a great market, but with such a great opportunity comes unique challenges. How do you access that captive audience of 800,000 medical patients? And how do you be efficient through that whole seed to sale value chain? And what we mean by seed to sale, that's from cultivation, manufacturing, distribution, retail, but also e-commerce, and then integrating payments throughout that. What I would say to folks that are looking at a technology vendor that fits all their needs is how are they compliant? How are they keeping you efficient within your day-to-day business operations? So example, whether that's feeding up into the traceability platform in Florida, those folks on the call maybe don't know or do. The traceability contract was awarded to a company called BioTrack by contract. And I'm glad I'm surrounded by lawyers here. By contract, that's an open platform, meaning the APIs, fancy word for data connecting hoses, from your operational software up into that traceability platform, that has to be open. So you're free to choose whatever vendor best suits your business needs. That's one. Two, how do you keep track of everything that's happening, all those core actions, from the creation events to the modification events to the sales events, to how are you retaining and building loyalty and brand equity into what you're doing so that you keep that piece of the pie amongst those 800,000 Florida patients? Those are the questions I would be asking. And then it's cannabis. The only thing constant is that everything changes. What does that vendor's government relations team look like? What does their compliance team look like? Are they tied into that state mandated platform? How are they tied into it? Am I doing dual entry in every action in my operational system? And then I have to repeat that same action into the state run traceability system. That's challenging. That's a lot of human error. That's a lot of overhead for your employee to be doing all those actions twice. And then lastly, I would say, where are you going? Where would you like to be? Like we talked about before, Courtney mentioned this. This is a huge opportunity. You're building, you've got, congratulations, you have your license. You have an infinite amount of opportunities. So you're looking at, I always use the analogy of a house. You're building a foundation, and part of that foundation is your software, but you're adding rooms constantly to that house. Those are additional retails, additional grows. Are you aligning yourself with a vendor that can easily scale that operation that started off in 2024, but is 10x larger in 2026? How do they scale? What's that support look like? And then how are you looking around the next corner from a compliance perspective?
And that's really important, being able to follow that growth. I mean, we went from 0 stores to over 400 stores in a very small number of years. We have MMTCs that are operating over 100 stores that have multiple cultivation facilities, some of whom have over 1 million square feet of cultivation space. And Florida regulatory program requires that literally every single plant from seed to sale be tracked. And that's when we talk about vertical integration. That's one entity, one license that is cultivating, that is processing. If you have edibles, you have to have a GMP certified kitchen. Even delivery cannot be, except in very limited circumstances, can't be, contracted with a third party, and can't wholesale except in very limited circumstances between licensees. So it's really critical, I think, that you again have the right back-end software. But I know you don't want it to be a Dutchie commercial, but let's make it a little bit of one, because I do want to talk a little bit about, beyond the seed to sale tracking and the POS, the back-end stuff. Dutchie also is very prominent on the front end, what the sort of user and the patient interface. So tell us a little bit about that and how it works, because I find it amazing that you can track inventory on a real-time basis. It's amazing to me.
Absolutely. Florida's rather unique. Every market's unique. Without federal framework, it's produced some interesting challenges. Florida in particular, sorry to throw acronyms, the MMUR, the patient portal registry system. If you're not tied into that system from a point of sale perspective, you are spending a lot of time understanding, hey, a patient walks in, what is that patient's allotment in real time? Am I in compliance and selling to that particular patient the specific categories that patient is allowed to purchase? And more importantly, how am I inducing that patient to come back to me and not another competitor? What are those data points that I'm collecting? And more importantly, how am I streamlining that whole transaction? Is it as easy as buying a 6-pack of beer at the liquor store? Or is it personalized, like sitting down with an actual consultant to understand what are those patient needs? Is that bandwidth there in understanding your patient, but making it as quick as easy if they want it to be, but also as personalized as it can be? And then lastly, integrated payments is a fun space in cannabis. How many different payment types are you offering that patient? A huge risk for operators is obviously carrying a lot of cash. It's a misnomer that all transactions have to be cash-based. There are options there, whether that's an integrated PIN debit solution, whether that's an automated ACH clearinghouse solution. There are questions to be asked, and I highly recommend those operators, those candidates for those applications, asking their vendor those questions. How do I make it easy if I want it to be easy and streamlined? Or how do I make it personalized? And how am I capturing the data around that interaction so I can then make data-driven decisions around marketing? I can then understand my key demographic that's pushing my margin, and then show, whether that's e-commerce, what have you, what makes me unique? How am I telling that story with the help of my software that I'm leveraging?
And it's really critical that you do work with the right vendors, because it's not only important from a business perspective, but let's face it, there's a regulatory component here, and there's not just a business perspective. The regulatory component is probably more critical than anything else. And Courtney, if in fact you are not compliant, there are ramifications with the state above and beyond, things that we've talked about in other seminars, like banking and potential money laundering issues and potential federal exposure and all that. And that's a topic to perhaps talk about another time. But you ultimately get your license. It doesn't mean that you have free reign to do whatever you want, does it?
No, no, it doesn't. And it starts from the moment you are lucky enough to receive your award, not your intent to award. That's an interesting component I at least didn't really touch on for the application. Once you receive your intent to award, it's an intent to award. You don't actually get to start until you receive your award after a lot of litigation or settlement. The state's done both. Legislation to issue licenses and litigation and settlement of litigation to issue the 22 licenses we have. But when you do ultimately receive your license, you begin actually in a pretty robust process to request cultivation authorization within the first 60 days, 120 days for processing, 180 days for dispensing authorization. And you are required to move through it at that pace. It requires many inspections, sometimes re-inspections or variances, of which you can only change something from your original application if it is the same quality or better. So of course, compliance is absolutely important. Tools that help keep you in compliance are critical, because Florida is so big and you're responsible for everything. You want to take advantage of every way to kind of belt and suspenders compliance you can. And the more you can automate that and make it more streamlined and efficient, I think any licensee is wise to do that. The API to the medical marijuana use registry is probably one of the most underrated ones, in my opinion. It was the first API the state did. It was actually not even mandated like the photo API for ID cards or the API for seed to sale. The department did that proactively to ensure, rather than relying on that human element, which means human error, to make sure the seed to sale is always in compliance with the patient registry. Being able to integrate those brings a ton of efficiencies. And there are a lot of really great examples of how licensees can get that done. But yes, we have a robust regulatory structure in Florida, and you'll be careful to not get any notices of noncompliance or fines.
Indeed, I tell people this is one of those industries where it's not easier to get forgiveness than permission. I say get permission because you don't want to be on the other end of a regulatory proceeding, good for the lawyers on the phone, but not good for our clients. And so we'd rather be working for our clients on positive stuff rather than having to defend them in regulatory proceedings. So Vijay, what's next? So we finished the round. The applications have been submitted the end of April. Tell me what these applicants can expect next from the Department of Health, OMMU, and then let's talk a little bit about your expectations, because I think that we can almost take it for granted. There's going to be litigation. What do you anticipate is going to happen over the next several months?
Yeah, for sure. So applications were submitted, application window has closed. Now OMMU is getting together, separating the applications, divvying it up, and starting to evaluate. There's about 3 phases for evaluating these MMTC applications: phase 1, phase 2, phase 3. I think what's particularly important for those who applied is when we get to the section concerning E&O letters, errors and omissions. Once an applicant has not, interfaced with legal counsel, then that is the time to do so. You definitely want to put your best foot forward when responding to these errors and omissions, because that can either make or break your application. It also allows you an opportunity to change some things concerning your applications. If things went a bit stale, then perhaps you may be able to put forth a new revised lease that is either of the same type of caliber, if not better. You have to hit that standard. But it's actually an opportunity where you would be able to supplement the application to a certain extent. Once that happens, then OMU, if they mirror the course of what happened with the Black farmer applicant class, they will take that back. You may have some avenues for additional correspondence. Then they would go ahead and issue their intent to award or intent to deny. And at that point, Florida being a very litigious state, and history, if it serves some course of what's going to happen in the future, most people will go ahead and enter courts. First, they would have to exhaust their administrative option, doing their petition for administrative hearing in DOA. And then if all else fails, go trial, civil. And again, like I said before, maybe temporary restraining order. But I think I wanted to touch on just, I guess, what to expect if you were to actually get that license. You know, as we kind of pointed out, as Courtney pointed out, you got 60 days to request your cultivation authorization form. And then once you do that, OMU is actually going to come back to your site to inspect and then say, hey, this is okay. You guys can go ahead and start ops. Then you'll be started working on processing. Or they say, hey, you know, here's some errors, here's some omissions, here's some deficiencies. Give us a response, and you have a time limit to provide that response. And you got to start those ops within those delineated time periods as well. 60 cultivation, 120 processing, 180 dispensing. So it's vitally important that you stay on course. And OMU actually mandated that you chart out your course when you provide your application as well. You have to draw out those timelines. But in essence, litigation, I presume.
Yeah, and do you anticipate that that'll delay the ultimate issuance of the licenses? When do you think we are going to see new kids on the block, so to speak? Because listen, they're of the 22 active licensees that presently exist in the state of Florida. Not all of them are actually operating. Well, they're all operating, but they don't all necessarily have dispensaries. And certainly some of them have sold very little product to patients. When do you think we're really going to see these stores open? And one of the reasons I want to talk about that is because I want to talk about the adult use initiative, which I'm going to ask Sally about next, and how that might interplay with this.
Yeah, and I think they might bump up to each other because, I mean, we're here on what, May 18th. It's more than a year after the application window closed for Black farmers, and still that license has not been awarded officially yet. I wouldn't be surprised if we come to sometime Q3 or Q2, perhaps even Q4 of 2024, and these 22 licenses, at least some of them are still in the air. You know, this is just a cause of concern for capital that entered to the market thinking it was going to be restricted. And then turns out, you know, come November 2024, something's on the ballot that opens it up. So I think that's a good segue to Sally to kind of comment on what her thoughts are concerning adult use.
Yeah, tell us about, Sally, the adult use initiative, where we are with it. Give me your thoughts of passage, and perhaps equally as important, I want to know how you think this is going to affect the existing medical program and what it does to the existing 31986 statutory structure for the medical program. A lot of questions, a lot to unpack.
Yes.
Jason, sorry.
Well, I mean, in general, I practice in 2 other states that have adult use programs, Oregon and Colorado. And I started in Colorado like a week after adult use actually passed. So I moved to Florida thinking it's going to happen any day now. It's been very frustrating to watch the Supreme Court shut down the previous attempts. And I've been very excited for this most recent initiative put forth by the Bellamy brothers. I love that it's come from a rock and roll band. Of course, True Leaf, our largest Florida MMTC, has heavily bankrolled that. I think close to the tune of was about $35-40 million or something like that. But this makes sense. In my personal opinion, marijuana should be legalized, but also if you have 100+ stores that you could open up to a much greater percentage of the population, it makes sense to bankroll it. They have reached all their, I believe, their percentage of required signatures, and they're getting Supreme Court review. Of course, the new negative news that we've seen this week is that the Attorney General, Ashley Moody, is, poised to fight it. I don't think that is a surprise to anyone. I cannot wait to see what creative argument she comes up with. It sounds like she believes that it might bust the clarity requirement. The two previous attempts from Regulate Florida and Make It Legal Florida both failed, I believe, due to the clarity requirement. And I think one of them was very confusing to the voters as to whether or not that would actually federally legalize everything. So I'm a bit Pollyanna about it. Courtney, Coppola, and I have discussed this offline a few times, but I believe that they did a great job this time around, making it very streamlined. They clearly make adult use marijuana legal, and they say that MMTCs or other similar entities or other state licensed entities can sell it. And I hope that they don't see that as a second subject that was being broached, and which would help it fail the Supreme Court review. I think if it does become legal or makes it to the ballot, I absolutely think it will pass. We used to see in this industry 60% being a really high threshold and almost unattainable, but I think seeing very Southern conservative states passing medical laws up in the 80% range, I think that we have a strong chance of having Florida pass of that 60% if it does make the ballot initiative.
Yeah, there's a lot of support out there nationally for adult use, and absolutely a ton of support for medical use of cannabis. So Courtney, tell us about assuming the sponsors of the bill have collected enough signatures, like 800,000 or so, that they need to make it to the next level. Now they have to, and our Attorney General Ashley Moody has publicly announced her intent to challenge the language before the Florida Supreme Court, and there's a single subject rule that they have to comply with. Tell us about the hurdles that they have to overcome, and if in fact it passes, how is it going to affect the industry? Does it provide for home grow? I mean, the answer I think is no. And how it's going to affect the existing regulatory framework for medical use.
Sure, and like Sally mentioned, this is a long, complicated process that we've all talked about. It had first we had to reach signature threshold, which is going extremely well. The Attorney General is reserving her right to argue. Single subject, that's another hurdle. Next is the Supreme Court in Florida. Hopefully we make it there. We've had others fail before. We've others succeed before on cannabis amendments in Florida. After that, when it is voted, what is a kind of tricky, complicated nuance in Florida's existing cannabis infrastructure, 3D1986, in that special session that I mentioned, that framework that implemented the constitutional amendment was established, included almost a self-destruct. And it said if there's another constitutional amendment that passes, this all goes away and has to be reconsidered. And if history is likely to repeat itself, which I think at least in this subject it is, I think we all would be smart to expect that the legislature would contemplate a structure to implement any new constitutional amendment, specifically a cannabis one. And not only would that impact the existing structure and our existing licensees, how they integrate into a new system when adult use passes in Florida. So I think it'll be extremely complicated. I'd be interested to see if they could get it done during regular session. We weren't successful to get all of that implementing language settled during regular session for the medical program. That's why we went into special session in 2017. So I think you could expect a lot of movement. If everything goes according to plan and it is passed, there will be a lot more to come after that as well.
So do you think that, assuming it passes and that it triggers the self-destruct button on 381-986, does that mean that we could theoretically have an entirely new cannabis program, medical or adult use, down in Florida? Would medical still exist? And if so, would it change dramatically? I know that some of this is reading tea leaves, so I certainly can't expect you to definitively answer these questions, but as one of the foremost cannabis policy folks in the state of Florida, you probably have a better handle on it than anybody else I can think of.
Well, thank you. It is definitely a lot of tea leaf reading, and each state handles it differently. What I know is Florida has a large and very sophisticated market. While we only have 22 operators, they're some of the biggest MSOs in the country. So they're very, very sophisticated, understand how this process works. So I don't anticipate them going away entirely. With that said, we have, our legislative processes can also be complicated, and they have shown interest in creating implementing language for these types of amendments. So I think it could change. I think the existing licensees in the market we have will be maintained in some way, but in some markets we see, medical entirely go away and being replaced. Ours is in Florida's constitution, so I don't think that's likely. But how it interacts with an adult use market will be interesting, but I don't think that you're going to see a complete undoing of everything Florida's built. The operators are big and sophisticated. Our program has come a very long way and is very sophisticated and, in my opinion, well run. And I think it will maintain the nuances that will happen certainly when 3D 1986 is readdressed. I think it'll be interesting and something everyone here will be probably heavily engaged on.
Sure, lots of questions. Maybe, I like the Colorado model in that, it's a very different model, but if you're a medical patient, you're not going to be taxed or taxed heavily. And presumably, there's going to be a pretty heavy tax in Florida on adult use cannabis. And so, it is a medical program. We do have 800,000 patients in the state. Some people like to, sort of scoff at that and say, well, they're not all necessarily patients, but nobody can deny that certainly lots of folks do need this medicine and don't have the financial wherewithal necessarily to get it. So I'm happy that there will be increased competition, and I'm certainly hopeful that there will not still be no taxes on the medical side. So we only have a few minutes left, and I do want to take a couple of questions. But before we do, Jason, this one's for you. You get your license. We make our way through litigation. We survive that. We now have been approved. We're starting to open stores. We're starting to cultivate. Tell me what sort of next? What are the critical sort of factors that need to be considered, or your top 3 or 4 most important things to run a successful medical marijuana treatment center in the state of Florida? Because we certainly know that Trulieve is the biggest operator in the state, and they have over 100 stores and public company, tremendously successful. Not all of the 22 are necessarily as financially successful. So what do you think are the sort of key, most important ingredients from perhaps marketing or sales that we people on today's program should take away?
Such a loaded question. So I'll give you the compliance answer first. I always start with compliance, and I'm always a half full type of person. And so when we do have federal framework and cannabis is recognized through the FDA, there are certain certifications that you will need, and you will be ahead of the game if you have those. ISO certification, HIPAA attestations, PCI compliance, a lot of acronyms there. I'm sorry. Ask those questions now and see if that vendor has them currently or can show you a roadmap to get there. That's throughout the value chain. Good manufacturing practices. There are a lot of protocols behind when we get to that day that, yes, this is federally regulated. The other one is more personal because I've been an advocate for the industry for decades now. Treat your employees as well as you would treat your patients. There is such high turnover in the cannabis industry amongst your employees. We've actually have some compelling data points around tipping, integrated tipping, and ensuring it's a direct correlation between, hey, are you offering tips to your employees, to them staying on with you, and building up that core value system. It's not financially motivated for the employees. Sometimes it is, but ensuring that you can hold on to that talent for a long period of time. And then the last one is obviously business 101, marketing, understanding who your key demographics are. My mom lives in Venice, Florida. I have got into a dispensary with her. She's a proud medical card holder, and I've seen good and bad experiences as my mom goes into different dispensaries. Are you making that easy for that patient, whether it is my mom, 72 in Venice, or whether that is a 20-something in Miami? So having that type of interaction that's going to create a loyal customer and build your brand loyalty and equity.
Fantastic. I
That
think
answers your
they're
question.
yeah, it does answer my question. I think they're very valid points. And by the way, as an attorney, I certainly will say treat your employees well, not only from a ultimately having a happy customer at the end of the day, but from a liability perspective, because certainly people, there are a lot of legacy operators in this space who have been operating before it was a legitimately recognized business. And now you have to deal with, and we've talked about 280E and tax issues. You also have to deal with HR issues. And certainly this industry is no different than any other industry that, you may find yourself defending lawsuits by anybody from management level people down to, the folks who are working in the stores. And so I would certainly say that to every employer in any space, take care of the people who are supposed to be taking care of you. But thank you very much for your comments. And I thank you all. I'm just looking to see if we have any questions. It looks like we have one. And forgive me for coming in, I'm blind. Could the panelists distinguish between some services that the OMMU may be more willing to allow to be outsourced? Could you use third-party customer service vendors? Can you have companies come in daily to collect and wash uniforms like Cintas? Do things like this still have to be under the licensee's roof or control? Anybody who wants to tackle that, feel free to do so.
I can take, I guess, the Cintas. So, I've reviewed plenty of Cintas agreements, a lot of the MSOs as well as MMTCs here in Florida like to utilize Cintas. I've seen Cintas utilized in other states. For those who are not familiar, Cintas can come in, replace your soap dispensers, towel holders. They also have a scrub vending program, where they actually put a locker in your system where employees can just swipe their ID card, get a new fresh garment in the cultivation facility, processing facility, toss their old one in, and it'll wash it for them. So that's certainly allowed. In terms of something that probably would not be so smiled upon, would be, say, like outsourcing like a call center, where you would need the people who are actually taking the calls to look up and have access to a patient's MMUR, because they would have to get credentialed, and they would have to be an employee, get fingerprinted as well. You could outsource to a call center, but you wouldn't be able to expect them to access patient records, assuming that they're not having their own MMUR profile to do that. So it really just depends. You have to really get down to the nitty gritty of what you expect this vendor or third party to do. And especially consider, we are still in the medical program. So, we have a lot of PHI out there. So if you are going to be contracting with third party vendor that's going to be privy to PHI, you need to definitely ensure that you have a business associate agreement executed between yourself as a covered entity, the MMTC, and then also the third party, the service provider. I don't know if anyone wants to add something.
Very, very, very informative, and I appreciate it. It looks like we're coming to the end of our time. Let me again thank the panelists, thank the sponsors. I hope this was informative. It was informative to me, and I've been doing this since 2013. So I can only imagine that everybody has gotten at least a nugget out of this. And all of our bios are available online. You could find our contact information. If you have questions, please feel free to call us, email us. I have worked with everybody here on the panel, and I know that they are all extremely responsive. So with that, I thank you. I thank you guys, and wish you all a great day. I'm going to be off to the C-Lab event in a little bit in Fort Lauderdale, and hopefully I'll see some of you there. Well, I probably won't see any of you there, come to think of it, but hopefully I'll see some other people on the line. Take care of yourselves.